officially begin the webinar. So thank you again so much for attending this morning. We know that it takes time out of your day, which is very busy. And we also want to thank Kelly for coming to speak to us today using her expertise. And with that, I'm going to pass it over to Kelly.
Thanks, Allison. As she said, I'm Kelly Mackey Foster. I am the Detroit Eviction Prevention Director at Lakeshore Legal Aid, and I'm also a board member of MICA. And so these topics are all near and dear to my heart. And when I'm looking at who's here from the chat, I'm like, those are my people. All right. Just a quick background. So I've been a housing and domestic violence attorney for my whole career, which has been about 17 years now. And I've worked at Legal Aid for like the last 20, and that's been in different locations throughout Michigan, but now concentrating on the city of Detroit. So I worked in the Lansing Legal Aid office, and so I have practiced in Corona and St. John's and Charlotte and East Lansing, and so kind of like rural locations, and then kind of mid-size locations. I'd say, like, I don't know, East Lansing is a good example of that. And then really small jurisdictions too, so like in Shiawassee County. And now in Detroit, it is the busiest court in the state of Michigan, in one of the busiest landlord tenant dockets in the whole country. And so that's kind of where I'm coming from. I always do a caveat at the beginning that I am extremely biased for tenants. So I know there's good landlords and there's bad tenants, but I generally speak from kind of the opposite because of my experience. So if you're a landlord out there and I say something that's like slumlord, I know the people are good landlords and are trying to do things for their tenants. All right, so okay. I start from the framework that housing is a human right. The United Nations recognizes that. There are federal laws in the US that cover some housing, and we have some state of Michigan laws that protect tenants, but not very many. So like Michigan is considered to be a not friendly to tenant state based on across the country. So that is what it is, I guess. I was going to say one other thing. Oh, okay. So what we're going to talk about today are the rights and responsibilities. The last webinar I did was focused on evictions. And so I touch on evictions a little bit, but not really the whole process. So I'm going to talk about leases and security deposits and fees, repairs, fair housing, and then a little eviction stuff. And so we're going to try to do questions throughout if we can manage that. If not, for sure, I'll stick around and if people have questions that they want to raise. All right. So first stop is where you can get more information, either for yourself or for the people that you serve. Two good resources are the Michigan Legal Help website and the Council Advocacy Law Line, which is called CALL, and CALL is staffed by attorneys who do intakes across the state. The Michigan Legal Help website has all sorts of great information about it, not just about housing law, but about all different kinds of areas of poverty law. So there's a live chat function that is usually staffed by attorneys, or law students. And so in real time, people can ask questions there. There's also some self-help locations across Michigan, which some of them are at courthouses, some of them are at libraries, where there's somebody who's there and has been trained kind of on navigating the system and helping people with questions. On the Michigan Legal Help website, you can also do an online application for legal assistance. Okay, I'm going to start from the basics of who is a tenant. Okay. So a tenant is anyone who lawfully entered the property at some point. And so people who lawfully enter the property are people who have a written lease or a verbal agreement with a owner or property manager, people who are living in your house for more than a couple of weeks. So like friend or relative who's staying on your couch. If you are the owner of the home, they become a tenant with some rights. There's also people who maybe lost their homes in tax or mortgage foreclosure foreclosure, and once the redemption period or the ability to pay ends, that person also becomes a tenant in that home. So who is not a tenant? So it's anybody who enters the property without permission of the owner or one of their agents. And so that's typically when people talk about squatters, which is a term that I personally hate, but that is the category of people. So like if somebody entered into a rural agreement with an owner to live there for 6 months, and then the owner sells the property to a new person, that tenant still entered the property lawfully because they have permission to be there, despite if the new owner doesn't want them to be.
We had a couple questions in the chat.
Yeah, okay.
So at what point do they become a tenant after sleeping on the couch?
So there's not like a bright line rule of when, but I would say like at 3 weeks probably.
And then do you have a citation for those definitions?
I can't, well, there is what's called the residential bench book, landlord tenant. That's kind of like the guide that judges use for landlord tenant. And so I don't know the site at the top of my head, but I can find that for you pretty quick. We have others, or keep going?
That was it for now.
Okay. So there's some kind of general advice that I tell everybody to do when they're moving into a property. And so as you work with people, these are important things, I think, to know when you're looking, or not when you're looking, when you're moving into a property. So I say you should always do an inventory checklist, which is like going room to room in the property and saying what damages are already there when you moved in. And that becomes important later if you are saying that there's a condition that needs to be changed or repaired, and looking at if it was already there when you lived there or when you moved in, or if it's something that maybe you did after. So the inventory checklist is really protection, I feel like, to the tenant. Even if a landlord doesn't give you one to do, I think you should still complete one, and there's lots online. I also think it's good to take pictures of the property when you are moving in. Like, what does it look like? What do the walls look like? What does carpet look like what's included? I also, if you sign documents, with our smartphones now, taking a picture of the documents is also really helpful, because you or your consumers may sign a lease and then never see it again. Like the landlord will say, okay, I've got this, I'll send you a copy, and then they never send you a copy. So if you take pictures of it, then you have access to it. I always say if there are repairs needed in the property, you need to notify the landlord or the property manager in writing. And in writing, texts and emails qualify for in writing. And so hanging on to those if you're making requests is important going forward if they're not doing the repairs. For security deposits, this is I have a couple slides just about security deposits, so this is just a preview. So security deposits can only be 1.5 months rent. Sometimes there are issues about that being more, and kind of what that looks like we'll talk about in a little bit. And then always get receipts for monthly payments if it's or pay in a trackable way, which means like in a bank account. And so I know that is not practical for a lot of people. So one is the landlord may not want to give a receipt, or just doesn't. Having like a log of the date that it was paid and how much is really helpful, like if you end up in court. And then the trackable way is, our clients often pay in cash and in money orders, and that's hard to prove in court that that's happened without something else kind of like helping it. So if you're going to pay in cash, like write that in a log if the landlord won't give you a receipt. So I see there's in the chat. So what about payments to hold an apartment? Is that considered a deposit? That's a great question. So Security deposit is something that can be returned to the tenant. And so if it's like a fee that you say, okay, you're going to hold this and you're going to get this back at the end of the term or when you move in, that's considered a security deposit and would be included in that 1.5 months rent. But if it's like a application fee to hold and they say it's just a fee and you don't have it, you don't get it back, it doesn't get counted in the amount of the security deposit. And I'm going to talk about security deposits a little bit more because I know that's kind of tricky.
So we're also getting, will PayPal, Venmo, or Cash App record the count? So will those count?
Yes, that's a great question.
And then folks are wondering if we can email the presentation out after, or we can pop it in the chat if that's okay with you.
Absolutely. Yep.
Okay.
And then we have a hand raised that I will allow to talk. So Doriana, if you want to unmute, you can ask your question.
Okay. I don't know if I can't hear her, so I'm going to just keep
Hello?
on. Oh, okay. Hi. Okay, I'm going to keep going. So just generally touching on other topics about the things that are tenants' rights. So they have a right to make a correction or what's considered to cure a notification of a lease violation or rules violation. The tenant has the right to the opportunity to repair or right that violation. And there's also what's called the Truth in Renting Act, which governs what can and can't be in a lease. I'll talk about that more. Late fees, there's rights about that. Security deposits. Tenants always have the right to request an inspection, whether that's from the local code compliance or if they're in subsidized housing from that vendor doing a housing and quality inspection. Your tenants are absolutely have the right to make those requests. Quiet enjoyment is a term that really means that there is not chaos around you from other tenants whose bad behavior impact your ability to use your housing. And so that it's also tricky what happens with quiet enjoyment. Landlords will use that though if you are the tenant who's just like making a miserable living experience for others. They can say you've violated the quiet enjoyment. We want you to move, and if you don't move, we're going to evict you. And then one other that's an important right is that tenants have the right to form a tenants union, and sometimes that is really powerful and important. So for instance, if you are in an apartment building and I don't know, they give everybody notices of their rent increasing, even though people are already in leases. Having a tenants union gives you some power to try to negotiate. And usually it's like there'll be somebody who is on there who is kind of like the expert and has lived there a long time or really knows landlord tenant laws. And I just think that forming tenants unions is really helpful. Like in Detroit, we have a property that in the last 2 weeks or so has been condemned. And so there's a tenants union who are trying to figure out, okay, what's going to happen going forward? Who are they going to be able to move back in? What's going to happen going forwards? And so all of those things can be addressed through that.
We had a few more questions. There's 3 in the chat and then 1 in the Q&A.
Okay. So I was threatened by my landlord due to nature's side screen door got broke, and he told me he would fix it and then said he's not going to fix it. I said, if I fix the door and take off my rent, would that be okay? He stated he would evict me. No, you absolutely could repair that and take it out of your rent. Okay. So for the chats, can quiet enjoyment be violated by a landlord's actions? Maybe, but it would be called something else. It would be considered like a lockout or constructive eviction or something like that if they're violating. Is it legal to ask tenant to make 3 times of what the rent is? Oh, their income? Yeah. Yeah, unless they're only requiring that out of certain people, in a discriminatory way, they can, like run credit checks and, eviction records and, unless it's a discriminatory reason, they can pretty much, make those collections. Okay.
Do you want me to read them? Is it easier?
So I think I'm going to pause them because I'm going to talk about some of
Okay.
those topics in a minute. So
Did you see the one at the top about is a lease enforceable if signed by both parties prior to effective date and exchange of keys?
yes.
Okay. We're good.
All right. Okay. So the Truth in Renting Act. This is an act that says what cannot be in a lease agreement and what has to be in a lease agreement. So if it's written, there's still a tenancy if there's no written lease, but this act itself focuses on what's in the lease. So there are prohibited causes, and they're mostly related to waiver of the tenant's rights. So if a lease says you are not entitled to getting a notice of eviction or entitled to have a hearing, or you're waiving your right to a jury, or like sometimes they'll say it's pocket judgment. So like that they automatically will not contest getting a judgment in court. Crazy. But there's also sometimes they'll talk about owing attorney fees and court costs in the lease, like how much that will be and when, and depending on what it says, that may also be a violation. Their treatment of the security deposit, there is information that has to be in there, but if it like forfeits the right to the security deposit without having anything to do about the rent that's owed or the utilities or damages, that could be a violation. Sometimes one of the other violations is assigning the landlord power of attorney, which seems kind of crazy, right? Like when would that happen? But it has. And so that is a banned provision in the Truth in Renting Act. Oh, there we go. Okay. So things that are required to be in a lease, there's not a whole lot, but it does have to include the name and address of the landlord and where rental payments should be sent or paid. There has to be information about the location of where the security deposit is being deposited. So like what bank is it at, where, like what's the address of that bank. There is also a provision. So in every rental agreement, there's this notice that I have that's in italics. And so that has to be in every lease agreement. And if it's not, that's a violation. So any of these things, if it's not in the written lease, it's a violation. So what happens when there's a violation? Like what is the process? So if a tenant has signed a lease and then they go talk to a lawyer and they're looking at it and it's like, oh, this says that you're waiving a jury and that you're automatically going to be assessed fees. Those are violations of the law. So from there, the tenant can provide a written notice. So that's like, old school letter, email. You could do it by chat, but I would say email is better. Notice of the violations in the lease, like what it actually is. And then the tenant, or not the tenant, the landlord has 20 days to fix the lease and to remove the illegal provisions and put things in there if it's not there that's needed. And after the 20 days pass, if the landlord has not made those corrections, the tenant then can sue the landlord and get money damages. So each violation in the lease is $250. So say there's one violation that's in the lease, they send the notice to the landlord doesn't take any corrective action. The tenant, even while they're living there, can file a case in small claims court and claim the money that's owed. One thing I want to talk a minute about is truth in renting and the duty to make repairs. So the Truth in Renting Act says that if a tenancy is for more than a year, then the duty to make repairs can be shifted to the tenant, saying the tenant's responsible for making repairs. And I hate this clause. And I usually am able to argue around it, but sometimes it gets pointed to. So really, if that is in a lease and it's been explained and understood about making the repairs, those repairs are only things that are minor. So landlord can't say that the tenant is responsible for paying to fix the furnace or I don't know, the roof, or I don't know, any of the bathrooms or things like that. Things that are major parts of the tenancy in the property, a landlord can't say, no, that's your duty to repair. They can say, like, I don't know, if light fixtures are broken or something, or cabinets, like that can be put at the tenant's responsibility. Okay. So before... okay, so what would you recommend to somebody who has an assessment of attorney fees and court costs in their lease and has already paid these fees before due to paying rent late in the past? So yeah, that's a violation of the Truth in Renting Act. And so I would tell that person to there's forms online like that Michigan Legal Help to provide notice to the landlord saying, nope, these provisions are illegal. Please change them. If you don't, then I can sue you for $250 of each one of the violations. If a tenant makes repairs to their own unit, is the landlord required to take that off their rent? I'm going to talk about that in just a minute. Okay. And there's one.
The Q&A says, what about coming into the home unannounced?
So that's they need to give 24-hour notice before they can come in, unless there is like an emergency, like, I don't know, the property's flooding, something like that. They have the ability to enter to correct that or deal with that. But otherwise, they need to give 24 hours notice. All right, I'm going to talk about fees. And so in the beginning, when I said that Michigan's not a very friendly tenant site or state, sorry, this is kind of where I'm talking about. So there are kind of two different tracks, right? So one is the security deposit track and one is the fees track. So the security deposit, if there's anything in the lease that says this may be returned to the tenant at some point, gets counted towards the Security Deposit Act. And that cannot be more than the 1.5 years rent. So if there is more than that, we say, okay, client has overpaid, and that needs to be included in their ledger as a credit because they paid that for security deposit when it actually wasn't. For the fees, they are something that is collected but not returnable. So if it's something that's saying, okay, this is needed because of X reason, their landlords can pretty much make that what they want it to be. There's not like a cap on how much there is or for what. And so as advocates, that is an area that is a problem in my opinion, but I cannot lobby. So just different types of fees. So an application fee, this is infuriating. So we have, like you'll have a tenant who is trying to get into housing, but they have to pay a $50 application fee to 3 different properties when they already don't have a lot of resources. And those properties can just keep it, even if they don't approve the tenant to come in. Crazy. Pet fees are okay. So if it's a pet, like a monthly fee that gets added to your rent, that's okay. Or if it's just an initial off the top fee, that is also okay. But if it's a pet deposit and it can be returned to the tenant, that makes it part of the 1.5 months rent that gets calculated. So they can ask for first and last month's rent. We see that a lot, right? We talked about security deposits. And so then there's this example here about FIDO that kind of illustrates how that plays out as a fee versus part of the security deposit. Oops. Okay, so the security deposit, as I said, can only be 1.5 times the monthly rent. If it's more than that, that should be and the tenant has paid it, that should be credited to their balance. I've got another example in there for you. So like what the cost is actually called isn't as important as if it's something that the landlord gets to keep or if it's something that can potentially be returned. So, there can be like $500 of fees for, I don't know, like your pet and credit worthiness or something. All of those things don't really have a cap on them, but the security deposit that the tenant can get back does. I think that's weird. All right, so, let me go back. So the security deposit, once it's time for move out, a landlord can keep the security deposit in a couple of different situations. So if tenant has not paid all of their rent that's owed, they can keep that part of the security deposit. If they haven't paid all of the utilities that are owed, that can be taken out of the deposit. And so for the utilities, there's a couple different things that happen. So one is if the landlord has been responsible for, I don't know, like paying the water bill, if the tenant has not paid that portion of the water bill, the landlord can keep that money. If the tenant had the water bill in their name and it was 3 months behind or something like that, and the landlord wants to bring in a new tenant, but they can't because that account is frozen because of what is owed for the last 3 months. In that scenario, the landlord can withhold the security deposit too. And then it's can be withheld if there's damage to the property that is beyond normal wear and tear. And what is normal wear and tear is contested, really. So, well, I'll go to the next one and then we'll talk about normal wear and tear.
We have a couple questions. And I also wanted to let folks know that Eric did put the PowerPoint in the chat. So if you want the PowerPoint, please grab it out of the chat. You should see it as a document and you can click on it and download it to your computer. We have in the Q&A, we have if the animal is a service or documented emotional support animal, can they charge a pet fee?
No.
Okay. And then we have in the chat, sorry, too many windows. To clarify, a landlord can ask for 1.5 times rent plus first and last month's rent to move in.
Yes.
And then should a tenant ask for an itemized list that breaks down the initial move-in costs?
Sure. Yeah.
And hopefully someone said they were confused about the 1.5 months, but someone just clarified. So hopefully that helped.
Yeah.
If a landlord says they will be there sometime that week, but doesn't give a date, is that considered 24-hour notice?
I would say no.
Okay, and then someone said, can they get the money back that they already paid? I'm not sure when that question came up, so I'm not sure what.
So I think like that depends on what the scenario is and what it was for. Maybe if you're talking about the application fees, like, so you can't get application fees back. Like
She said
under
court
the law.
fees. She was asking about court fees.
Oh, so that depends. If you're in eviction court, there is like a statutory amount that a landlord can collect because they're in court that gets entered in with the final judgment in the court case. But if there are court costs or attorney fees that are assessed like just in a ledger, they can't do that. That like whatever has been paid, that needs to be allocated to the balance of what's owed.
And that's it for now.
Okay.
And we have a thank you.
Awesome. All right, so security deposit timeline at move out. So this is important because it talks about when the landlord can actually keep the security deposit, right? So we gave those scenarios about for utilities, for utilities, damages to the property, or back rent. So landlord, tenant has to give written notice within 4 days of move out of the new address for them. So if a tenant like just moves out and doesn't give the landlord a new address, the landlord can argue and will win that they don't have to return the security deposit because they didn't have notice within the 4 days of where to send communications about it. So that's a thing that lots of people don't know and is super important. And security deposits are really, so for legal aid, typically our highest priority is keeping people housed, and security deposits are after they're being housed. And so like we'll give advice and like tell people how to represent themselves, but it's not normally a type of case that a tenant would get represented in, which is awful because there's a lot of money that's going back and forth that the tenant should be getting back, who's already in a situation where I'm sure they need those back. Okay,
I
so
think that's really helpful to know, especially when I did frontline work. So
yeah,
if you just really quick could say maybe like the top ones that are most likely to get help from legal aid, because when I was taking calls and I would send people, I really would want to give them a correct expectation.
yeah, sure. And so there's different programs that cover different parts of the state. So like if you are up in Marquette, legal aid there, you'll have like one attorney for like 4 counties. And so it has to be like a really, really egregious situation for a legal aid lawyer to pick that up. They always give people advice no matter what. They should be giving also like advice on how to represent themselves. But then when you come to lower Michigan, in the rural areas, that's harder too because there's not enough legal aid attorneys. But when you're in like a more suburban or urban area, typically the types of cases that will get accepted for representation are cases where there's a dispute about who is the actual owner, if there is a problem about an estate, if there has been a lockout and claims, and I'm going to talk about lockout in a minute, and or if there was force or threat of force that is being used. And it depends on where in the life of the case it is. So if it's the very beginning of a case, and those are one of the situations that makes it more likely for a legal aid attorney to pick up and take, versus you've already gotten a judgment against you for whatever reason it is, those are less likely to be taken for representation by a legal aid attorney. We'll also do land contracts, and so land contracts are cases that you're more likely to get representation if you're able to. Hopefully that helps. I don't know.
It does help. Thank you.
Okay, so if the tenant gave the new address within the 4 days, the landlord has to return the security deposit within 30 days. So there's a couple situations when they don't have to return the full amount in 30 days. And that is, as I've been saying, rent or utilities are owed unless there are damages to the property. And if the landlord is alleging that they're keeping the security deposit because there's damages to the property, they have to send the tenant a list, an itemized list of what those damages are and what the cost is. So this is kind of where the normal wear and tear kind of arguments can take place. So, I'll use an example of like carpet. So for carpet, a tenant has lived there for 10 years and, by the doors and the areas that get used the most, the carpet has been like run down because it's poor quality. That's normal wear and tear. Like a tenant should not be required to pay for that carpeting. If a tenant has lived there for 10 years and their dog has been using it as a bathroom, a tenant can be responsible for repairing that or replacing that carpet. Yeah. And so whether or not it's normal wear and tear is like really a case by case basis, like knowing what actually happened or not. So if you're a tenant, you get this list of damages, you have 7 days to respond to it. So in 7 days, you come back and say, sorry, it's Friday. I'm like, you can come back and say this is bullshit, which is not the legal term. But you could set a list of responses to the damages that you're disputing it and for what reason. And if the tenant sends that response to the damages, the landlord has 45 days from when the move out was. So it's really 15 more days, if you will, to sue to keep the security deposit. They have to sue to keep the security deposit. If they do not file a case and they're withholding some of it and it's in dispute, the tenant can file a claim against the landlord to get their security deposit back. And we often, so legal aid, those are cases where we likely are going to have somebody go through small claims court to try to get that money back. And small claims courts in Michigan are really used to that scenario of security deposits and like understand that area of the law. You can also, if the landlord doesn't follow the law for whatever reason, maybe they're outside the timeline or didn't provide the list of damages when that's what they're saying they're going to withhold for, the tenant can get double the amount of the security deposit back in that case. So Michigan Legal Help is the website. You search security deposit, there's going to be all sorts of information for you. So will be articles, frequently asked questions. There is like a do-it-yourself kit that you can enter, and I always say it's like TurboTax, where you enter your information and it creates pleadings and what needs to get filed for you because you entered in the information. And then it'll also give you instructions on how to go to court, what you need to do with paperwork. All of that can be uploaded, or not uploaded, it's downloaded from the Michigan Legal Help website.
Do you know the name of that website?
Yep. And so it is michiganlegalhelp.org. So if you do like spell out Michigan Legal Help, that'll get you there. If you do MI Legal Help, that'll get you there too. And in my PowerPoint at the very end, there's a live link in it to Michigan Legal Help. All right, do we have anything about security deposits before I jump to the next one? What's the name of the website? We got that. Is there a limit on the time after move out for tenants to sue for their deposit? It's a year. That's a really good question. I should put that in my PowerPoint. Okay. All right. So we've been talking about fees. Late fees are one where there are some restrictions on how much it can actually be. So late fees cannot be considered what is a penalty for not paying rent on time. It has to be as related to an administrative cost that the landlord had because the tenant was late in their rent. So if there's a fee that's like, I don't know, if you don't pay by the 5th of the month, you have a $20 late fee. That'll be okay. If it is, you pay, or if you don't pay after the 5th day, it's $20. And then if you don't pay the next on the 6th, it's another $20. And on the 7th, it's another $20. And the 8th, it's another $20. That's illegal. They can't do all of that. But on a month-to-month basis, fees can be assessed. How much it can be generally in Michigan, if it's over $40, really realistically, that's something that I'm going to challenge. And if I'm in court, I'm going to challenge and ask the landlord to explain what they do with that late fee. What do they use it for? Do they actually need it? Is it actually accomplishing anything, or is it just a penalty? Some judges have like a bright line rule of how much they'll allow or not. And so one of the courts I used to practice in, $40 was the amount, and automatically didn't want to hear anything about it. If it was more than that, that wasn't okay. Are there late fee questions?
There's quite a few here.
So can the landlord deduct the rent and late fees from the security deposit? Yes, at the end of the lease. Or like when it's move out time. What about the second late fee charge after the 15th of the month? So I think that would depend on how much the fee is. So like if it's $20, if not paid by the 5th, and then it's like $40 if it's not paid by the 15th, that's probably okay because the whole month equals 40. But if it's more than that, no. All right, let's see. Here we go. $50 per item or in total. So I think that's like the $50 is a month per month, really. Can they charge a late fee per day? No. Can they charge late fees if they don't file notice to quit? Yes. Can the landlord charge $35 one day and then charge $1 per day after? Is that okay? Whew. So if it's $1, I think that probably, I think it's a violation. I would argue that it's not. And that would depend on what judge you got. So if it's $1 a day, like maybe they would allow that. But if it's, $5 a day, they for sure wouldn't. And I know that's clear as mud.
And then we have Fraley Calderwood with their hand raised. Fraley, if you want to unmute yourself, you can ask your question.
Thank you. I think you just answered it before I could lower my hand, but I've got a couple landlords who have like $2 a day and $3 a day they're charging. If a client doesn't pay the late fee, would that be considered, illegal, or is that still, if it's under 5, they can get away with it?
I think if it's like day by day under 5, like if it's more than $1, I think that's not okay. What really is, if it's, so say you get a $50 late fee, if you're not paid by whatever the 5th is usually what it says, right? And it's $50, there can't be another day by day that's added onto that. Like the $50 should cover that month and not additional fees.
Okay, if they're just charging like an additional $2 a day without like a flat like $50, is that okay, or does it have to be like a one flat fee charge?
No, as long as it's like a minimal charge by day, that's okay.
Okay.
Yeah.
Thank you.
Yeah, that's a great question.
And then it looks like there's one last question in the Q&A.
Where are we at? I have a landlord that charges $50 after the 5th and then another $30 after the 15th. Yeah, no, that is not okay. That is illegal. And so what really the tenant should do is, it probably won't happen until they're like at the end of living there. But basically saying the total of 80, like that needs to be taken off. And then like divided by however many months it is to get to what the number of like $40 to $50 a month. That's fair. Yeah, $80 for late fees. I mean, this goes back to the point of, are the fees or late fees like reasonably related to a cost that the landlord has for them being late? Like, so, they've got somebody is working in a, I don't like a rental office. And so, they've got to issue notices and whatever their labor is to do that, and like keeping track of who's late and how much. Like those are pretty legitimate reasons to assess a late fee, but like not $100. So they would have to go into the judge and explain how they get to $100 per month for a late fee, which will be impossible. So the hard thing is that you get assessed late fees and then you get behind because they're like you're paying, but you owe a late fee for last month. And so they're going to say you didn't pay your full month this month because they took part of it and assessed it to your late fees. And then it just keeps snowballing like that until you're at a place where you're getting a notice of eviction for non-payment of rent. Yeah. Okay. Let's see what we're going to talk about next. Okay, repairs. So if there are repairs that are needed, and generally it needs to be something that is not just like cosmetic. So like my example about the cabinets is not a super high priority, but like, I don't know, anything like we're talking about basements flooding, which is a very common thing. So basement floods, you have to provide notice to the landlord. Hey, the basement is flooded. Please come help fix it. And that should be in writing. And so an email is beautiful, but also text would be okay. And if the landlord says, as part of that process, the landlord's not like, okay, I'm on top of it, I'm going to get it fixed for you. The tenant has two options. So one is they can withhold that month's rent if they've given the landlord notice about the problem, withhold that month's rent and until the problem is corrected. Or they can make the repairs themselves and then deduct that amount of the repairs from the monthly rent. Talk more about that in a second. So you got to give notice when there's need for repairs. What is excellent is if you can have code compliance, and which is called a handful of different things in different communities, come in and do an inspection, which should be free. They will issue like a corrective order that will lay out, hey, I was here on this date and like there were live wires here and the toilet doesn't work and there's not hot water and you have this date to correct it. Like once you get to court, that's a really powerful document because the judge like sees that as a neutral party who is very clearly saying this is what's wrong. Okay, so if you're doing the withholding the rent, it talks about escrow. So this is like a tip for you. Escrow doesn't necessarily have to be in a separate bank account. What it has to be is that the tenant has the money is the question. So say the tenant gives notice, withholds rent, keeps the money in their bank account, and then the repairs are made or aren't made when you're in court, as long as you can say, okay, I have the 3 months rent that we could pay. Like if we were ordered to, we could pay today. That's more important than saying, oh, it's in this account over here. And I think that's just really based on practicality of opening another bank account or not. So that's my tip. Okay, so if you do withhold the rent and there's still repairs that need to be made, the tenant then has claims that they can sue the landlord for. So if they're let's give me an example. So greater than $200 a day or actual damages based on the repair. So it has to be a major repair for the tenant to be able to get this $200 a day for the violations. But like any of the examples I've been saying about utilities or like the furnace or hot water, roof caving in, all of those things, the landlord, I would say, was owes the tenant $200 a day from when the tenant gave the notice to the landlord until when it's fixed. So well, I've just put in here too. So repair order in a court case. So typically what we'll do is if we have a tenant who's in court and they tell us one of those terrible conditions, we're going to ask the judge to issue a repair order that gives them a timeline to do it. And not at the end of the case, like to do it within the next couple of days. So like somebody doesn't have hot water, that's a lot. I would be in court and I would be saying, Your Honor, this tenant does not have hot water, and that's been that way for this many days. I want to assess damages by the day and you to issue a court order that says they have to restore the water heater or whatever the problem actually is. This $200 a day, if the tenant wants to sue the landlord, they have 1 year to do that. So there's 1 year statute of limitations. And then use or threat of force be treble damages. So treble damages is basically 3 times the statutory damages. So 200 times 3 for each day if they physically came and moved your stuff out or you out, or they made threats that people were going to come and put them out. Like that's potential treble damages, which is a lot. Or it could be the actual damages, I should say that. So if the tenant has actual damages, like they had to go to a hotel and like they paid their out of pocket, if that's more than $200 a day, and you can prove that it went out that much, then you can claim the higher amount. That is really hard to do, just based on like you have to have a receipt for whatever's going out. You have to be able to demonstrate like this is only because of this issue, not something else. And so generally we tell everybody it's $200 a day because you don't necessarily have to prove anything other than that condition exists at that time. So if they fail to make repairs, the other piece is repair and deduct, and that was one of the questions earlier. So the tenant, well, let's do an example. A tenant's, I don't know, we'll keep using hot water. Yeah. So the tenant's water heater is broken and not working, and the tenant gave notice to the landlord of, hey, this is broken. Please come and fix it. So they can withhold their rent because it's not being fixed, or they can hire somebody or themselves if they can do that. They can hire somebody to make the correction or make the repair, and then whatever amount that cost was, they can deduct that amount from the monthly rental payment. So your monthly rent is $500. It was $200 to get the water heater fixed. You give notice to the landlord that says, I am giving you $300 because I made this repair and it was this much. Here you go. And it's up to the tenant. Like they can really do either of those things. Just some tips about repair and deduct and what happens. So if like you're going to have a professional come in and do it, having more than one quote is very helpful. Having the quotes, if you do hire someone, if that person is a close family friend or a relative, that's a challenge. Like that's going to get challenged in court of it really didn't cost this amount. But it could also be like maybe you personally made that repair because you're handy like that. And so you can take your receipt for whatever the materials were that you needed and deduct that. I think you can also, depending on how much time it took, say this much is for my labor to correct it, if you can like figure out how much that is. That'll get a lot of back and forth about like what the actual cost is, but it's a thing that a tenant can argue is like, I put my personal time into fixing this water heater and it took me an hour. And so a normal handyman charges $20 an hour, and I'm just making that up. So landlord, I'm also withholding $20 for my labor to fix it. This is one where the pictures are incredibly important. Oops. Oh man, I just did something. Okay. So the pictures are incredibly important. It's also a when the inventory checklist at the move-in is important too. So like if you have an inventory checklist that says hot water heater working, and then it stops working, you can say on this date, look at this inventory checklist and look at when this stopped working. So I'll probably have a couple questions, I think.
Yep, so the first one was about the basement flooding.
Okay. I should have done my warning at the very beginning. You're gonna see some cats while I'm talking. Speaking of basement flooding, is cleaning the aftermath part of the landlord's responsibility of correcting the flooding problem? Yes. And that's generally because there needs to be like a remediation in the cleaning, because that typically will mean that there have been sewage that's there. So that is their responsibility. If they aren't doing it, that's a perfect example of when you should repair and deduct, because if you have the ability to, you don't want to live with sewage and like live sewage in your basement. But if your landlord is not making like efforts right away to come and correct that, if you have the money to do it, it's better to just do it so that it's safe for your family, and then charge the landlord for however much it costs to get it cleaned.
Do you want to expand just a little bit on remediation, what that would entail?
Yeah, so for the flooding, like there has to be like, there's companies who all they do is remediation after floods. And so remediation could be like in the basement, like maybe half of the drywall has to be replaced because that was the water line. Maybe it just that, you know, if there's carpet down there, like that needs to be all pulled out. If there is, the damage to personal property is very hard in a flooding case because it's not necessarily the landlord's fault that the flood happened. If it's based on weather, if it's based on something else, then it could be the landlord's fault about damage to personal property, but that's not an automatic. That's like depends on what the facts are. Those are the main things I can think of. Oh, well, so with the remediation, like sometimes it means you gotta bring in giant fans and to dry everything out. Like that's a part of remediation too. I have any others? Let's see.
Yep.
Okay.
So the next question was right below that one.
Oh, let me go.
It says, can a client show the funds in a gold or silver account?
I don't know what that means.
For the escrow?
In a gold or civil?
Do they mean like actual gold?
Oh, I can't think of any reason why they couldn't. As long as they're gonna like liquidate it to then give it to the landlord. Like, I don't know, I guess that could work.
And then it says if the landlord is waiting for the vendor to be able to come out, does that count for the $200 a day?
That's a great question. So if the landlord is legitimately trying to like fix the problem, most courts aren't going to do the $200 a day as long as they're like acting in good faith and like trying to make the repair. Most judges will say, unless it's for a really, really long time, most judges will say, I'm not going to assess the $200 because this is not the landlord's fault.
Okay. Then we have, is it legal for a landlord at first to file a non-payment case for rent, but then after tenant states in court that they are holding due to repairs, and then landlord refiles as termination of tenancy as retaliation? Can they legally do that?
So that's a good example of things that really happen. So, it depends on where it is in the case. So, if the landlord has just filed the complaint for non-payment, they have the right to just dismiss that, until there's been a hearing or until a tenant or their attorney appears in court. So if it's before they have an attorney or in court and the landlord decides to dismiss the case, they can really do that for any reason. They don't have to have anybody's agreement. It just is a notice that gets filed to the court. If you have a hearing that's already happened and in the example is like, oh, they're going to bring a Michigan Consumer Protection Act, which is where the $200 come from, can't claim against me. Ooh, I'm going to dismiss because I don't want to deal with that here. That's a violation of the law. So they have to get the tenant or their attorney's agreement to dismiss the case. So we would like file a motion to the judge saying, no, this case can't be or shouldn't be dismissed because we have these counterclaims that are here. Please reinstate the case. And then, so this is another thing that's really hard is, so I'm going to talk about retaliatory eviction in a moment. But like, non-payment of rent and they want to, like, they dismiss that case and they want to do a termination of tenancy, they have to give a new 30-day notice that they're trying to terminate the tenancy. They can't count any of the notice or the time that was happening in the non-payment case. They basically have to start over at 30 or after 30 days.
And there's one more in the Q&A. So if the landlord has agreed to pay for electric each month and shuts off the electric without notice, what would the recourse be for the tenant?
$200 a day. And so if they, well, that's going to be in another slide in a little bit. So I'm going to talk about that more. Okay. All right. So very briefly talking about rights of the tenants. So one of them is fair housing. And so people need to be free from discrimination, both in the landlord tenant context, but also in mortgage lending and homeownership. And so there are people who categories that fall under what's called a protected class. And if someone is a member of one of these protected classes, and the landlord does something egregious, I'm going to give you a list in a minute, that could potentially be a violation of fair housing, which also has money that the client is then entitled to. Let's client, the tenant. Okay, so things that would violate the Fair Housing Act: refusal to rent or sell based on one of those protected classes, different terms of tenancy. So like if you're a family, you got some minor kids, and so they put in different rules about what the kids can do, but the neighbor doesn't have that restriction, that's a violation of the Fair Housing Act. Applying different rental rates or fees based on one of those categories, not okay. Restricting access to amenities, like, I don't know, if you got like a common room or something like that, or sexual harassment absolutely counts under Fair Housing Act. And this is one that we like legitimately see with some frequency, which is terrible in other ways. General threats about removing you from the housing, or actions that are happening, or if the landlord is straight up calling you slurs. So like one of my cases, the landlord was really trying to get her out. She was a Black woman, they were white, and they would come and call her the N-word over and over and over again. And we sued them for that under Fair Housing and Elliott Larson, and we won. So my client got some money because they were being so terrible to her and discriminatory based on race. Okay. Another piece of the Fair Housing Act is what's called a reasonable accommodation. There's another act too. It's called the Rehabilitation Act 504. You may hear of the 504 said. And so what those protect are if someone has a disability, they can make a request to change or make an exception or adjust a rule or policy if it is needed because of their disability. So that's a request that they should make in writing, although it doesn't necessarily have to be. If a tenant says, hey, I need this because of this, they're supposed to honor that. As a lawyer, I want that in writing. I want them to say, I'm requesting this change so that I can prove that they actually made the request and when it was. So different reasons why a tenant can make a reasonable accommodation request. So say the rental due date is before they get their disability check. So they can't pay on the 3rd because they don't get their disability check until the 5th. That's a reasonable accommodation that has to be granted. The service animals. And so if you have a service animal, you should be exempt from those pet fees that we talked about at the very beginning. Requesting a close parking spot. One that comes up with some frequency is if it's a big complex and you're living on the 3rd floor, but you have limited mobility, you can ask to move to the 1st floor when there's vacancy there. Cleaning requirements, I always say this. So those are typically for people who are hoarders and they're getting notices we're going to evict you because of the condition of the property. And a tenant can say, okay, I have a disability. I need some accommodations based on that. Please give me more time to make these corrective actions, and I will do certain things by dates for checkpoints to make sure that it's safe. Probationary behavioral agreements. So I put this in here because sometimes our tenants have mental health issues that can then present and disturb the quiet enjoyment of their neighbors, or maybe they make threats to a property manager. Maybe they're off their medications and they do, so one of my cases, they are off their medication and they we're making all sorts of loud noises. You can make an agreement with the landlord, hey, you're right. I shouldn't have been doing that. It's because of my mental health issues. And then you have to get a tenant to acknowledge they have mental health issues. Please let me stay. I'm going back on my medications. If it happens again, then that's a different scenario. Along with the reasonable accommodations, the accommodations are based on policies. But then there's also reasonable modifications, and those are based on structural changes to the property that are needed because of a disability. So it could be things like ramps to the front door. Maybe you need doors widened for your wheelchair. Maybe you need grab bars in your bathroom, or maybe what you need is a walk-in shower. That becomes an issue over here we're going to talk about. Or alarm systems. This is one of my real cases. Is I had a deaf client who there were multiple fire alarms that went off and he had no idea because it was in the middle of the night and he couldn't hear. And so we made a reasonable modification request for him to get the flashing lights installed in his unit. Okay, then who pays for it? This is what I'm gonna go back to the shower modifications for. So if it is an extremely high cost, that would be an undue burden, and the landlord can show I own 4 houses and I can't replace this shower. I just can't. And that's okay in some circumstances. What's not okay is if the tenant makes that request for the walk-in shower, the landlord says no, the tenant can then themselves make that modification to the property based on their disability. And generally that's okay because it increases the value for the landlord. Okay, I think there's a couple questions.
You have some questions. Yep. So we have, I thought well, not a question, but someone's asking if age is a protected class.
Yes.
Okay. What if disruptions are due to children?
That's a good one. So my answer is it depends. So people can't be treated differently because they have children. The only exception of that really is if it's a senior or disabled property. So like they can say you can't have kids here. And so like if you're talking about like a probationary agreement because of a child's behavior, like that's reasonable, okay? Like, so my example for that is he had my client had a disabled son who set fire to a dumpster. And I said, don't evict them. Here's what we're doing to try like to get his mental health like reeled in. Like that's a okay thing to do under the Fair Housing Act too.
And then we have one more. If a tenant's child is receiving SSI, can they request rent, like the due date being changed because of
Yeah.
their child's income, or does it have to be the parent's income?
No, I would say like if you're using, which you can, part of that disability income of your child to pay the rent, like, yes, that's legit. And there's a lot of good law that says that's legit.
And then one more just came in. I have a client whose landlord comes to the apartment to make sure it's clean. They have 3 small children in the house, so it's messy, but no damage or harm is coming to the unit. The landlord has said he will evict them for this. Can he do this? I thought that as long as no damage was being done, they were okay. There is no hoarding or anything even remotely like that. Example, he pointed out that there was laundry next to the door to go out for washing.
Yeah, that's crazy. So under the Fair Housing Act, I would want to know, are they doing the same inspections with the neighbors or other people in the property? Probably not. And so that is an example of a policy that landlord is doing that is a violation or discrimination because of the kids. So it kind of goes back to the when a landlord can come in. So a landlord can come in for making repairs, or even if they like want to sell the property, or I think doing an inspection is also okay. If it's something that's on a reoccurring regular basis, I would argue that that is discrimination. And like threaten to sue the landlord if they don't stop.
We're caught up and we have a thank you very much.
All right. Okay, this is about retaliation that got raised earlier. So a tenant has the right to assert their rights under the Fair Housing Act or anything else, really. So the tenant has the right to request an inspection from a government agency. They have the right to file a complaint with a government agency. So like if it's subsidized housing and the tenant files a HUD complaint for whatever host of reasons, or maybe there was sexual harassment and the tenant filed the complaint with the Michigan Department of Civil Rights. If the landlord within 90 days of the tenant asserting their rights files an eviction against them, the court presumes that it is retaliatory eviction within those 90 days. Outside of the 90 days and the assertion of rights, we can't make a retaliatory eviction. And so like one exception of this to think about though is like non-payment of rent. So if you go to code compliance and they issue a corrective order and then the next week you don't pay your rent or don't pay it again, the landlord can still file a non-payment of rent case against you if you have not been paying, but they can't terminate your tenancy within those 90 days as long as we can show that you actually requested assistance through a government agency. Okay, so prohibited evictions. There are terms that are used that all mean the same thing. So sometimes it's called self-help eviction, sometimes it's called constructive eviction, sometimes it's called a lockout, and all of those mean the same thing, which are there is an action or behavior that is designed to force the tenant out because of the conditions that the landlord is doing. So that could be a lot of different things. So constructive eviction can be that the force that I was talking about, so like going in and locking units, coming to a property with guns and making a threat that they're coming back tomorrow. That would be a constructive eviction that they would get money for, and it would be based on force, so you get like the triple damages there. But it could also be just coming and changing the locks, or coming in and saying, oh, I didn't know you still lived here. I took all of your property out and did whatever with it. The turning off utilities is also considered a constructive eviction or a lockout. And so all of these things that happen, these are what also give rise to that $200 a day. So if any of those things have happened, so let's talk, say like the unit is locked and our client, oh, this is actual real one. So our tenant lives in a property that is like a gated area, and you have to have a, I don't know, a remote to get into the gate. And the landlord changed the remote system that's used and gave everybody but this client access to the new one. That is a constructive eviction because he's intentionally prohibiting this tenant from entering the property. That was just one that was like last week. The shutting off of the utilities, now it goes back again. If the landlord is responsible for providing and paying for the utilities and they shut it off, that's a constructive eviction. However, if the utility gets shut off because the tenant has the responsibility to pay and they haven't paid, that's not a constructive eviction. I see there's a couple of chats. Oh, the clean. Okay. So I've got a couple more slides and we've got, okay, around 10 minutes. So I'm going to talk about court and evictions quickly. All right. So somebody comes to you and says, help, I'm being evicted. There's really only one scenario where someone is actually being evicted and have to be out. And that is when there is a writ, an order of notice to vacate that's the writ of eviction is signed by a judge. That's the only point where a tenant has to be out of the property. If you are anywhere in the process before that judge signs what's called the writ of eviction, you're not evicted yet. You could move voluntarily, but you do not have to move until a court officer comes and tells you, I'm going to be back in 24 hours. And the 24 hours pass, and that's when court officers can come in and like in Detroit, they bring a dumpster. In other areas, they like put all the personal property out on the street, and once it's on the street, like anybody can come and take it, and that the landlord won't be liable to the tenant for that personal property being taken because they're at the point where there's a writ of eviction. Okay, I just put here what the different steps are in the eviction process.
I did put in the chat the link to Understanding the Eviction Process webinar.
Oh, can you say that again?
I put in the chat the link to the Understanding the Eviction Process webinar that you did, so folks can really get all of this information in depth.
Yeah, that's awesome. So that's the timeline. All right, so if you are at a point where a tenant is being sued for eviction, either because of non-payment of rent or to terminate a tenancy, or there's other limited categories. There are a couple of things that the tenant is entitled to. So one is a notice of what is happening, both why they're being evicted and what it actually means. And then they're also entitled to an opportunity to be heard. And that is having a hearing with a judge. In subsidized housing, that could mean notice of termination of a voucher and an informal hearing. Like that is notice and an opportunity to be heard. The first time that a tenant goes to court and they don't have a lawyer, they can ask for an adjournment to get legal counsel, or to try to get legal counsel. And those are pretty much automatically given. Yes. So in eviction court, you can raise any defenses that you have orally when you're in front of the judge. Other types of lawsuits, you have to file an answer or counterclaim, like that's a pleading that gets filed with the court. And eviction court's different. They don't have to put it in writing. You can just raise it and tell the judge what the defense is. So like, Judge, I think that this is retaliatory because a month ago I went to the Department of Civil Rights and said he was sexually harassing me, and now here we are in a termination of tenancy. The tenant also has the right to potentially have an abatement of rent if they can show poor conditions. And so like those repairs that were failed to be made, or other issues that were at the property, you can go and say, Judge, this I pay $500 a month in rent. I didn't have access to a bathroom for 3 months. My property like was not the value of $500. It was more like you got to try and like make up a number, and there's not a strict definition of what that should be. But maybe you're just saying like I should have $200 a month taken off because I didn't have a bathroom. If you didn't have a bathroom, I would say like all of the cost should be off. But so that's kind of an example of the tenants do have the right to have an adjustment to what is owed if there are repair problems. If a tenant enters into a consent judgment with their landlord, they have 3 days that they can file to undo that. And so this is usually what happens if they're unrepresented. If you have a lawyer, you can't do this 3 days judgment. But if you're representing yourself, you can. And what this usually happens is you go to court, the landlord says, here is the judgment. You need this judgment to get help from DHHS. You need to sign this. And then they go home and they tell their sister what just happened, and the sister's like, no, that's not true. The tenant can go and say, hey, wait, I think I have rights that I didn't know about. Please set aside this judgment and let us have a hearing. Tenants also have the right to a jury trial, so they can request that orally or in writing. And then at the end of a case, tenants have 10 days to appeal their judgment to the circuit court. It goes really quick. All right, so here's some resources for you guys. The very first one, the practical guide for tenants and landlords, that's one of my favorite resources. It's put together by MSU and the Michigan legislature. And so it has like FAQs and some timelines and great charts. And so I just encourage any tenants or landlords or people who work there to, or work with that population to review it because it's pretty awesome.
So
And
Kelly, I see those are links, but we actually turned your PowerPoint into a PDF because it has your name on it.
Thank you.
So if folks Googled that, would they be able to find it pretty easily?
Yes.
Okay.
Yes. Same with the Michigan Legal Help. If you Google that, it'll get you right there. And then the last one is the hotline number for to talk to a lawyer to do an intake for legal advice or representation. All right. So it is that's the end of my slides. If people have other questions that we have not talked about.
Fantastic. Great job getting through all of that, even a little early because we started late. So I will give a second for folks to put any last minute questions in the chat. I know how precious wow, it is for people to be able to talk to someone that's a lawyer. So we'll give you a minute. And then while we wait for folks to come in, I just again want to thank everyone for attending today. I know that an hour and a half out of your day when you're helping clients is a lot of time. So we hope you got something out of this. We want to thank Kelly for her time. She had to prepare and show up today. So we really, really appreciate that. There's a survey that will pop up at the end. If you can fill that out, that helps us provide you trainings that are helpful to you, and also will provide Kelly feedback for when she does things in the future. And This is recorded if you want other folks to watch it, but it will not be up for a few months. So we post a new video once a month. So her last one was posted in August and it's already been watched 185 times. So
Really?
yep. So we hope that our YouTube page is helpful to you all. And then one last plug, Micah is a member-based organization. So if this was helpful to you and you can't believe it's free, then you can become a member. An individual membership is $45 a year, which is the price of probably like half of an in-person training. And we provide 12 free ones a year. And we also have a sliding scale for agencies and COC membership that can all be found on our website. I am just seeing a bunch of thank yous coming in. Eric, let me know. I'm sorry if you can hear my baby. Eric, let me know if you're seeing any questions, but I'm just seeing, oh, I see one. Where did it go?
I got it. So
Thanks.
what does the law have to say about tenants videotaping vendors in their unit working, interactions with the landlord, etc.?
So I don't necessarily think that there is something that applies to that. So I think what you're saying is like, a tenant like you're a tenant and I don't know, like a repairman comes and you tape that interaction, I think is what you're saying. I think that you would need to, if it was for the sole let me say this. So if it was a sole purpose of just recording that interaction, you would have to tell the person that you were recording them. If you have like the Ring doorbell or a security cam that runs throughout the day, that necessarily you wouldn't have to provide notice to that and it would be all right. I think that's what you mean.
But it is 11:31, so I do want to let folks out on time because I know that everyone's busy. And again, thank you so much. We appreciate you being here and we'll see you at the next webinar.
Thanks. Have a good weekend.